It's Conduit News Radio with Paul Harrell.
All right, folks, welcome back to the program this morning. Good morning to some of you taking your first sips of coffee. Thanks for doing that with us here at the intersection of conservative ideas and reality. Want to welcome back to the program. We've got State Representative Jimmy Gazaway on the line. He's calling in. Jimmy, how are you, sir?
I'm doing well. Good morning, Paul.
Good morning. I wanted to have you on just because, I guess the last time we had you on, it was before the election. We were talking about tort reform and everything. That was something that was on the forefront of a lot of Arkansans' minds who were about to go to the polls and vote. And then, of course, the Supreme Court, threw it off the ballot, so no one actually got to vote on it. But now lawmakers are starting to relook at this issue and try again, from what I can tell. I've got a headline here, John Moritz in the Democrat Gazette this morning. Legislators renew efforts to change tort laws in the state. In newest proposals, gone is control over rules, fees, caps, and damages stay. What are your thoughts on the process right now? And there are two competing ideas down there, right?
That's right. First of all, I guess I'm not that surprised to see it back. As you said, the Supreme Court struck issue 1 from the ballot, which was formerly SJR 8 when we voted on it in the legislature. I'm not sure that they're ever going to stop. So the special interests are back, and quite frankly, I'm not surprised. But the proposal is different this year. What they did the last time, of course, and the reason the Supreme Court struck it from the ballot is because they, as the Supreme Court said, impermissibly log rolled. They put about 4 different things into one proposed amendment. It did everything from capped attorney's fees to it capped punitive damages, it capped non-economic damages, it gave the legislature the power over court rulemaking authority. And then the Supreme Court said you can't put all those things into one amendment. People won't know what they're voting on. So they're back this year, and it just so happens that it's SJR 8 again. And this year they have kind of wised up a little bit, and they have limited the text to just allowing the legislature to set caps on punitive and non-economic damages. And so that's what the SJR 8 will do this year. And
So for people out there, Jimmy, for people out there who are not business owners, go over punitive damages, define that, and then define economic damages, non-economic damages.
Right. So punitive damages are the damages that we recognize in the law that are designed to punish bad actors. So if a large corporation, for example, you saw those in the thing is with the Ford Pinto case where they knew that the gas tanks would explode, but yet they made a conscious decision to, instead of correct the problem, just produce the cars with the defects and pay whatever damages might result. And so when that bad conduct was discovered, they were able to be punished. You can't put a corporation in jail. And so the way we punish bad behavior by corporations is we allow punitive damages to be assessed against them where they have to pay out. And so that's punitive damages. Again, those are damages designed to punish. And then there are non-economic damages, which SJR 8 would also cap. And those are the damages that we recognize in the law for pain and suffering, loss and permanent disfigurement, loss of a bodily member or function, a permanent disfigurement, and loss of life. And so, that was one of the biggest objections. It was certainly the biggest problem that I had with the Tort Reform Amendment Issue 1 last time was the cap on non-economic damages, because it puts a value, or it will allow the legislature to put a cap or a value on a human life, because that's part of the definition of non-economic damages, the loss of life. And that's why, I sort of object to it and inject into it myself.
Okay, so you're telling me right now what they're debating is they're just debating whether or not they should be able to have a debate on what the cap should be for punitive or non-economic damages. Now, there are two proposals out there. Now, I understand one would just allow the legislature to cap punitive damages, and then the other would allow them to cap both. Do I have that right?
That's right. So there has been another amendment, a proposed amendment filed. Senator Stubblefield in the Senate and Representative Cap in the House have filed alternative amendment that would allow the legislature to only cap punitive damages. And just to speak of that briefly, my thoughts on that, I don't necessarily like it, but given, if I had to choose between the two, between allowing the legislature to cap punitive and non-economic, or just allowing the legislature to cap punitive, I would rather allow the legislature to just cap punitive because, those are damages that don't get assessed that often, and it's something that might truly have an effect on the business community. And an argument that I hear pretty often for capping punitive damages is that we allow the legislature, for example, to set the range of punishment in a criminal case. And so, in the Constitution, we recognize you don't have cruel and unusual punishments. The legislature, in its authority, can set a range of punishment for a crime. And, the analogy would be that the legislature should also be able to set a cap on the punitive damage, which is designed to punish, just like we set a range of punishment. But quickly, I do want to make a distinction between setting a cap on punitive, again, which I don't really like, but I'm okay with, and setting a cap on non-economic damages, because I think there's an important distinction. Make a person whole. And I'm talking about people in this state who are injured, who, they may be a paraplegic, quadriplegic, they may be permanently disabled, they may be scarred beyond recognition, or they may be, the family members of someone who'd lost their life. And when we cap the jury's ability to award damages for that, we have gone too far, and we have entered into a realm where the legislature doesn't have any business. That's the province of a jury. And since 1874 in the Arkansas Constitution, it always has been.
We are talking with State Representative Jimmy Gazaway from District 57, talking about these competing tort reform measures that are being talked about right now. Well, let me ask you this, Jimmy: is there any realm, when we say this word tort reform or this phrase tort reform, do you think that there's anything out there that needs to be done right now? I mean, because I do hear from some business owners out there who do want some sort of tort reform to try to stop what they call frivolous lawsuits. People that actually even attempt to fake injuries, at their stores and things like that, and then sue the company. Is that just something people have to tolerate, or is there something that can be done to try to address those issues?
I don't think so. I think that it is an issue that we have to look at seriously. I've heard those same concerns, and I'm not going to say that they aren't legitimate concerns. One of the things that I proposed last session when we looked at this issue was, giving the judges more power to assess fines against attorneys who who are deemed to have filed a frivolous lawsuit, and to make the other side have to pay the attorney's fees of, someone who's had a frivolous lawsuit filed against them. I think there are common sense things like that would go a long way to curbing, frivolous lawsuits to the extent that we have them. I think there are some common sense things like that. But capping non-economic damages, capping a jury's ability, which, by the way, we preach local control. We hear that preached in Little Rock so much. So there's nothing more local than a jury. And capping a jury's ability to award damages to make somebody whole, who again may be paraplegic or quadriplegic, who may have been abused or neglected in a nursing home, or in a situation where someone has lost their life, that's wrong. And they're at it again, and that's what we're up against.
So if they go through with this, one or the other, if they go with the amended version that's saying, hey, we want to have the ability to debate how much the cap should be on punitive damages, or if they go with, we want to have the ability to have the discussion. Of course, we know special interests will be involved. I mean, if they were to have that ability to discuss it and pass future legislation, I mean, that'll be fascinating to watch. I guess, but this will be a constitutional amendment. Is that what this would be again?
It absolutely would be. And so I want to address two of the points that you just made there. Number one, this will be a constitutional amendment. And so I think that the natural question would be, why are we amending the Constitution to give the legislature the power to put caps on punitive and potentially non-economic damages? And the answer to that, I know that we've got a lot of patriots out there listening, a lot of constitutionalists out there listening. And I think this is important to know that since 1874 in the Arkansas Constitution, it's Article resulting in death or for injuries to persons or property. And in cases of death, for such injuries, the right of action shall survive, and the General Assembly shall prescribe for whose benefit such action shall be prosecuted. So again, it goes back to that general provision that exists in the Constitution that has been in there since 1874, that no act of the General Assembly shall limit the amount of damages to be recovered for injuries resulting in death or for injuries to persons or property. That was amended in 1938 by Amendment 26, which set up the workers' compensation system in Arkansas. And so in workers' comp situations, we do recognize some limits for different kinds of injuries and things like that, because that was a measure that was designed to protect employers. But the reason they have to amend the Constitution is because that provision that says the General Assembly, no act of the General Assembly shall limit damages in death or for injuries resulting to persons or property, they have to amend that section of the Constitution that's been in there since 1874.
What was going on in 1874 to make them amend it then?
Well, that was when our Constitution was drafted following the Civil War. And so...
Okay, seems like I heard, maybe I'm mistaken. Seems like I heard, there was a lot of, I don't know if it had to do with the railroad. It seems like I heard it. Go ahead.
You're right. You're right. There were, and Joey McCutcheon is kind of the expert on this, but I do recall that back then, basically the railroads had almost complete immunity, and they were trying to have laws passed that would limit their liability if the railroads killed someone, and so that was made a part of our Constitution very wisely, I would say.
Interesting history. Well, go ahead.
Well, the second point that I wanted to make with regard to amending the Constitution to allow the legislature, as you've said, to have the debate, because that's what I've heard so many legislators say is, well, this will just allow the legislature to have the debate about setting caps, and we can set those caps at whatever we want. And my response to that, Paul, would be, the only true roadmap that we have here is history. And if we look back at what they did, and I was here in the legislature last session when they tried to do this, they tried to limit non-economic damages to $250,000. And I'll tell you, if it would not have been for pro-life Republicans in the House of Representatives who stood up for that effort, if it had not been for that, at that cap, they would have tried to put that cap out at $250,000. It got raised at the last minute to $500,000, which, by the way, is still an abomination and far too low for any kind of damages we would recognize for somebody who's lost their life. It would put a limit of $500,000 on life. So they can say all day that this is just going to allow us to have the debate. Well, I've seen that debate before, and I know what they've tried to do, and they tried to make it 250, and they've tried to put it out to the people of Arkansas at 500,000, and don't think that those won't be the same type of efforts that they'll undertake again.
State Representative Jimmy Gazaway, it's always a pleasure to have you on, sir. We appreciate it.
All right, Paul. Thank you so much.
All right. Have a good day. We'll see you down there.